In our first panel, we explore what citizens expect from the legal profession, especially regarding the changes in legal organizational and technological innovation. Now we will turn on the other side and we will see what are the needs of the professional themselves. And we will explore the challenges and the limits that comes with this innovation in the different legal professions. You know, the legal landscape is evolving quickly, very quickly, and it's difficult to follow up all this new innovation in the different professions. Especially in our professions, we have almost every year new changes about the digitalization. New technologies, higher client expectation, and changing regulation means that we must stay ready while holding our core values that defines our different legal professions. Today, so as I said, I'm very happy to have a panel of high-level experts, a lawyer, 2 judges, and court staff who will share their insights on how these shifts are affecting their daily life. Together, we will discuss what the different legal professions need to respond to these demands and also to consider the risk that are linked with all this innovation. So I look forward to insightful conversation, and I'm confident that the expertise of our panelists will help us to better understand what will be the future of our legal professions. So first, let's start with the lawyers. I have the pleasure of welcoming Alex Tallon, who is lawyer here at the Brussels Bars and is also vice president of CCBE. Alex, as a representative of the European bar lawyers, how do you see innovation changing the practice of law, particularly in the field of access to justice, so as we said in the first panel, of the justiciable?
Thank you, Patrick, for the question. It's, of course, an important question, but like for the introduction, I have, in fact, 2 problems. The first one is not to repeat what was said before, because even if we have another point of view, I think everything was said until now. And the second thing is, of course, that when you are asking what is the changing in the future about these new technologies and the access to justice and the legal services for the clients, I don't know who said that it is very difficult to predict, surely when it concerns the future. And so make predictions of that is rather difficult also, because when you see the evolution of all this modern technology, you are always one war behind, of one challenge behind. The evolution is so fast, and it's hard to follow, and it's hard to follow for the profession. Like it's also, I think, hard to follow for the courts and for all the legal profession. And when we speak about the access to justice and to improve it, I must say, as a lawyer, the first thing to improve it really is to raise the legal aid in the country, and then you will improve the access to justice. But if you want to do it through modern technology, like this was said before, I don't think that will improve access to justice if you want it or not. It's also to make with the cost of the justice. If it is more expensive, it will be, of course, more difficult to have for the citizen access to justice. And I don't think that as such modern technology is automatically decreasing of costs and it's automatically less expensive justice. So be aware of that, but we must try to use the tools that we have to have a more efficient justice, of course, also more quality or even equal quality. And of course, perhaps if possible, also less expenses, less costs for the client. And I must divide it also, I think, with 2 sorts of work that we deliver. That's the first is the defense, what we call defense, and that are the procedures and what are the modern tools in the procedure. And a part of that you have perhaps not so much the topic for a meeting between legal professionals, between judges and lawyers, but it's the pure legal advice for the client, but is also, of course, a very important part of the work delivered by the lawyers. In the procedures, you see that modern technology, and I don't speak about AI, but modern technology is something that can facilitate the communication, can facilitate the access to files, can facilitate also the work of the lawyer for documentation, research, etc. So that are really things that we can use and that we use, and that also the judges will use. But when we see what is for this moment used in the courtrooms as new technology, we must assess that it is underutilized for the possibilities there are. And there was something in the Justice Scoreboard that was important, I think, when they say that when they speak about the use of modern technology, that you have the legal rules and the proceedings were adapted to the modern technology. But if you put on the scale of 10 that these rules are covering 10 points, you see that the implementation of the modern technology in the judiciary is only till 5 for the moment. So there is an underutilization of the possibilities there are, that can be improved also in the collaboration. Like Judge Di Pasquale said, it's important for the collaboration. And in Belgium, you have a good example of that, because the collaboration between lawyers and the law profession and the judiciary and Minister of Justice made that we have some platforms that was developed in this collaboration. So this is important, but I think we must do more. And then we come to the observation that it is to make with underfunding of the judiciary, but there also we have already the remark that it will be difficult to increase the funds for the justice. So I don't know really where the proper solution can be for that. The other solution was also already evoked, that was to say, yes, you can also have other, because at the end of the day, of course, the access to justice is dispute resolution, and you have also alternative dispute resolutions. But alternative dispute resolution is necessarily more expensive than the normal dispute resolution, because judiciary is free. If you go to, you must pay the lawyer, but you don't pay the judges, but you pay the mediators, and you must pay also the arbiters. So it's a more private justice, in fact, or a private solution of dispute resolution. But I'm only questioning also that sort of solutions. If you are a part of the more funding of the judiciary to implement properly the modern technologies, because also in Belgium, for example, but also I think in many other countries, we have no digital file, and that is rather paradoxical, that we can upload all the documents digitally. We must upload it digitally, and we must send it to the courts digitally. But there they are printed. That was also said, I think, by Christian Lemke. They must print it, and the judges often, and more often than less often, ask us to bring a paper file to the hearings to be sure that they have it, because it's not always printed, and then they don't have it, or when it is printed, it is perhaps not so good classified, and they don't like it very much. So we must bring it still. So this is a great paradox, that we have not a digital file as such that we can handle it. What we have in most of the legal firms and the legal offices for the moment. And that's then the other aspect of these modern technology is, of course, in the legal advice sector. And there we must, there we have competition. That's another market regulation, of course, competition, and every law office has its own tools. That also we have much more different sort of law firms and different sort of clients. So everybody must a little bit know what he is using. There you have two problems, I think, for the bar associations. Is first, not to create a gap between, yes, the big law firms who can have enough resources for AI and these modern tools for facilitating the work and also increasing the quality, for example, of the work. And then the other individual laws, also smaller sized law firms, who has perhaps more difficulties. And I think the bar associations must make it sure that also to have the same level playing field. It's also important. It's not only same playing field between judges and lawyers, also sometimes questioning, but they are also between the lawyers to have the same level playing field. And the second thing, when using modern technology, is to be sure that the core values of our profession are respected, because of course that also is questioning the independence, the confidentiality of the communication. You know that when you use AI and put your documents in an AI platform, what are they doing with all this information? Of course, you are violating, in fact, your professional secrecy when doing it. But if you don't do it, perhaps you are have also more problems to deliver a good legal service. So that is the other challenge, I think, also for the legal services as such, and the legal advice that we deliver, is to make sure that these core values are still respected by the profession.
Thank you a lot. When I listen to you, I feel we are a little bit in between situation. We have a lot of tools, but it's not easy to use this tool on the right way. And some lawyers are interested to use them, some are still not interested. And I think we have to go to a commitment from all legal professionals, not only from the law, but everyone, to go and to embrace, so as said by Francesco Di Pasqua, and embrace all this innovation, not only by AI, but all the innovation, and take it. I think it's also a question of surviving for our legal service. So I think we're really in the in-between, to use it or not to use it. I will now go to the second speaker, Mr. Edouard Rottier, who is judge referee and head of the open data unit of the French Cour de Cassation. And Edouard, open data is in the French judiciary will lead to the online publication of millions of court decisions per year. How is this project expected to meet the needs of the legal professions while fully respecting the fundamental rights? And when I say fundamental rights, I speak in particular on rights of privacy and data protection.
Many thanks, Patrick, for giving me the opportunity to present on our project at the French Court of Cassation, to publish under some limitations that are mainly aimed at protecting fundamental rights, all court decisions. So we have this project, which I will first present briefly, and then I will answer more precisely your question. So the Court of Cassation, which is in France the Supreme Court on civil and criminal matters, is responsible for the publication not only of its own decisions, around 15,000 decisions a year, but also for the publication of the decision of lower civil and criminal courts, which will indeed, as you said, lead to the publication of more than 2 million decisions a year when the project is fully deployed. At this stage, the project of open data of court decisions in France, just a quick precision that I only speak for the civil and criminal matters, because in France we have two orders of courts. Civil and criminal courts depend on what we call the judicial justice, with it said the Court of Cassation, and administrative cases is a different order of courts with the Conseil d'État and administrative courts and administrative tribunals. So I only speak about civil and criminal cases, but there is the same for administrative cases, but it is not conducted by the Court of Cassation, but it is conducted by the French Conseil d'État. So the 2 million decisions concern the civil and criminal matters. At this stage, the project is deployed for all the decisions rendered by the Court of Cassation, whether civil or criminal. It is also deployed for all the civil decisions rendered by Courts of Appeal, and it is deployed for around two-thirds of the civil decisions rendered by courts of first instance. And very soon, by the end of 2025, all the civil decisions rendered in civil matters will be deployed. This will include specialized courts, such as the tribunals of commerce and work litigation courts. And criminal courts of first instance and appeal will follow after 2025. This was a brief presentation of the project in order to understand. And now let's speak about protecting fundamental rights within this project. We have two different layers of protection of fundamental rights. The first layer of protection is the limitation of the scope of decisions to be published as open data. But we intend to publish as much decisions as possible, but we do not publish all decisions. Only decisions that are rendered publicly are published. So it's the first limitation, and this concerns both civil and criminal cases. And this limitation to decisions that are rendered publicly is, of course, mainly intended at protecting privacy. As regards criminal cases, there is a second limitation. Only decisions that are definitive will be published. And this limitation intends to protect the right to a fair trial and the presumption of innocence. So the first layer of protection, limitation of the scope. And now we have a second layer of protection, which is a little more complex, and I will explain more. And the second layer is what you mentioned. It is the pseudonymization of the decisions. In practice, pseudonymization means in practice that we remove a certain number of elements from the decision. The names and first names of all individuals, so natural persons, are always removed, except those of professionals such as judges, clerks, and lawyers. And some other elements are usually very frequently removed, almost always, such as addresses, social security numbers, bank accounts. And then there are some categories of data that are generally not removed, but would be removed, especially in certain matters. So there is dates of birth, of death, of marriage, dates of divorce, and also the name of legal persons. So usually the name of legal persons are published, but on some occasions they will not be published. The final decision on which elements shall be removed lies on the judge who renders the decision. However, there are recommendations from the Court of Cassation on which categories of data shall generally be removed with regard to the matter of the case. And from experience, we now know that these recommendations are followed in a vast majority of cases. So to sum it up, we always remove names and first names of natural persons, except professionals. And then all other elements, it is decided by the judge who renders the decisions, but there are recommendations of the Court of Cassation which are generally followed. And also to have a complete presentation, there is a judicial remedy for any person interested to ask for the removal of any element in the decisions that have been published. So once the decisions are published, it is still possible to have some elements removed, and there is a judicial remedy for that purpose. So this is how, for the legal and organizational point of view, we ensure the protection of fundamental rights. But of course, this pseudonymization has very important technical aspects. So how to remove this name, first name, addresses, social security numbers, and so on and so forth. And this is quite a technical challenge to ensure this pseudonymization of such a huge amount of documents. This requires to recognize all the elements to be occulted, that is to say, names, addresses, and so on. And this has required some technological innovation. If I come back in time 10 years ago, there was, it may seem surprising today, but there was no reliable technical solution on the market, just to identify names, addresses, and so on, which today seems quite an easy task for artificial intelligence. The only solution 10 years ago was what is called, some of you already know that very well, but I explain for those who are less familiar with artificial intelligence. The only solution that was available on the market, widely available 10 years ago, was what is called rule-based artificial intelligence. So what it is, it means that human has to write down rules to be followed by the software in order to recognize the elements. So just to take an example, a rule to recognize a name would be, as an example, if there is the word Mr., then the word after Mr. is a name. So it seems simple, but in practice, it didn't work very well. Then a few years ago, the solutions based on machine learning became much more widely available. And now the approach is totally different with machine learning, because it's not for the human to write down rules to be followed by the software, but it is for the machine to learn from examples. So again, if I take my use case of pseudonymization of court decisions, in this case, the example is given to the machine, to the software, by the algorithm, by annotating, or in other words, labeling the entities to be recognized. In practice, we annotate where are the names, addresses, and so on in the decisions, and then the algorithms learns to recognize those entities without writing down any rule. It's based on a mathematical, statistical approach. And in this case, 5 years ago, so in 2018, we saw with a proof of concept that it was possible to have quite good results with only a few hundred of annotated decisions. And since it seemed to work, we had the opportunity to have a public funding and to build an in-house data science team, which was by far the most cost-effective and qualitative solution. In practice, in 2019, we recruited 2 data scientists, so experts in artificial intelligence, in particular machine learning. We bought, it was not so expensive, we bought a powerful computer to run the algorithm. It was 20,000 euros, so quite some money, but still affordable for such projects. And by the end of the year 2019, we already had a very performant solution, which has been regularly improved since then. So this is also how, also by technological innovation, we try to ensure this data protection and privacy. And now I will speak about the impact on the general public, and which is the topic of a roundtable on the legal professional of these projects and the legal needs of the professional. Because I spoke about technological innovation, but the most innovative aspects that we see in this project are not these technological innovations, but are the impact on legal professionals. It is what in our mind is really innovative, and we change the way to have a judicial or legal debate. There are, in fact, 2 main objectives in this project, as seen from the point of view of the Court of Cassation, because there are also other objectives from other point of view, economical and so on. But from the point of view of the Court of Cassation, the 2 main objectives of this project of open data of court decisions are firstly, transparency of justice as a safeguard for democracy and rule of law. So it is to say that you have everything on the internet, everyone can have a look, make its own opinion on the justice of
So
the.
it's open to everyone.
Yes, 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 and freely available. There is nothing to pay. So it's first objective of transparency of justice. But secondly, it is also to improve the quality, the consistency, and the efficiency of the judicial process. And this is where, in fact, we think, or I think, that there is indeed a pressing need for all legal professionals, be it judges, lawyers, all legal professionals, to have this full access to as much court decisions as possible, and not only the decisions of the highest courts, which we have for a long time in most of European countries, but also of the lower courts. So in the case of France, courts of first instance and courts of appeal, mainly. Why? Because we see that it is really a way to improve the quality of the dialogue of all the I find the word, all the stakeholders in a judicial process. So dialogue of the judges, dialogue of the lawyers, dialogue of the lawyers and the judges, dialogue of the lawyers and their clients, because with this project, we improve the level, we improve very much the level of knowledge of not only how law is applied, how law is interpreted, because it is sufficient to have the decision of the highest courts to know that, how law shall be interpreted under the highest courts, but also how law is applied in practice on concrete cases, how there are maybe some doctrinal debates on the application, how maybe there is a rule that is set by the highest courts, maybe there is no debate, or maybe there is a debate on this rule. There may be also some new legal questions that will appear first at a before a lower courts, and with this project, anybody can see how this new legal question is dealt with. You can see also, you can see also the appreciation of the facts. So all of that is to, we think that it could positively affect the work of all legal professionals, and there is really a notion, and I believe that, of collective intelligence, which is the main point of this project regarding the needs of legal professionals.
It's a very impressive project. First, a little back question. After, if we have time, I have another question. How do you finance it? Because we are talking the first panel, the problem of financing. Here, Alexander Olba, he also said the problems of financing. How do you get to, because it's a huge project, how do you in a few words?
In a few words, I already mentioned that we had an in-house team, and it was much less costly than working with a contractor.
Okay.
So in fact, it's 2 data scientists, so the salary of 2 data scientists. The computer, I mentioned 22,000 euros. And then, of course, now the project is much more expensive because there is a industrialization. But at first, it was not very expensive.
Okay, perfect. So we see even with less money, we can do a lot of things. So I think it's a very good example of innovation with also the funds we have at our disposal. I will now go to the court staff and to Wolfgang Lämmer, who is the honorary president of the E.U.R. It's the European Union of Rechtspfleger. Wolfgang, court staff plays an important role in implementing new technologies. And what are the effects of this innovation in the everyday life of court staff?
Yeah, thank you, Patrick. I'm honored and a little bit surprised that I was invited again since last year. But it's good for me, I think. Yeah, let me first come to a question that is always between our organizations that we have, the question, what's the definition of court staff? You're talking to me as a court staff, and I think, yeah, that's right. Because usually when people think of courts, they think of judges or even prosecutors, and never about the fact that it's a complete organization. A complete organization means that there are also other professions involved in running a court, if you say so. And the point is that every profession depends on the other. Nothing works alone. And in my opinion, then court staff is the covering term for all employees, including judges, including prosecutors, Rechtspflegers, support staff, and constables. And in old times, we even had microphone. I thought I was loud enough. In old times, we even had cleaning cleaning stuff for the courts that were part of the court staff. Nowadays, it's outsourced. Even constables are outsourced sometimes, so it's a little bit difficult. So each of those professions has to fulfill special tasks that are defined by law or employment contract, and the difference may be seen by the degree of responsibility assigned to each task, but still no works without the other. So let me come to the question itself. What effect of digitalization has had the greatest impact? You say everyday life. Yes, everyday life is more than the court. My answer to this is digital networking. Because when I was in the court, working there, I remember the days when the normal way for a court file was arriving at the post office of the court, where the constables were responsible for pre-sorting and later bringing them to the correct office. And there, the secretaries were responsible for the assignment to the right case and putting it to the removal compartment for the Rechtspfleger or the judge. And later, the constables came along to carry the paper files to the offices of the Rechtspfleger or the judge, where the decision had to be made or written down on a blank sheet of paper or a form that had to be filled out. Of course, the same constables had to carry them back to the office of the writing office. And the employees there transferred everything into a printed form and put it into the right removal compartment. So I guess you already see what I'm referring to. It was a workflow that needed a certain amount of human power. And in the second half of the 1990s, so around 30 years ago in Germany, I'm talking about Germany because I'm German. In the second half of the 1990s, these things started to change. A group of people, including myself, were asked, do you have any ideas how we can make work easier? And we came to the conclusion that the first step would be to put a computer on every desk. So we can avoid using typewriters that are still in use there, even if we're electrical typewriters. We had the idea that it would be much easier by not printing the raw files or the filled forms and carry them from room to room, but just saving them on a disk and carry this. It's much lighter. And after that, we became real futuristic and thought it would even be easier just to connect the computers between the different rooms with a cable and find a way to transfer the text directly. From that point, things have taken a life of their own. Networking was born and found its way to normal life. First, inside one court, but later, of course, between the courts, between the high courts, and whatever you want. In my country, North Rhine-Westphalia, in Germany, we even built up our own network center. We have our own, how you call that, computer network base, like Amazon. No, not so big. So at that time, or let's say at the end of the 1990s, I had even a much crazier idea. Why shouldn't all paper files one day be replaced by data in a network? Of course, I was smiled with pity, and the justice system wouldn't even be capable of that in 100 years. And now we are at that point where some have a new vision, the vision that AI might take over a lot of tasks. They are now covered by human work. I hear the others say that wouldn't happen in 100 years. But as we already heard before, it already happens. And let me give one example of something that already is usable in the German law system. That is the small claim files in Germany, and they are automatic. We have an automatic small claim file. For instance, big companies like Telecom, who have to get money from their customers and don't get it, they don't have to go to the court. They just have to put a file into a server that stands in 2 points in North Rhine-Westphalia and get an automated decision made by a computer. And if nobody is against this, then this is the law decision that can be enforced. Only if somebody says, no, I don't agree to that, then it can happen that it goes to the court. So we already have AI doing court decisions or former court decisions, because now there are no court decisions anymore. And that will happen maybe to other things too, but I think we'll come to this point later.
Thank you, Wolfgang. And here to you, I see that the evolution is from a long time. And so we are talking now that innovation is coming now, but it's not the case. I remember when I was younger, I think I was 10 or 11, I was in the office of my father, was also just an officer, and he opened Word. It was for him amazing to open this treatment, to put the text, to print it. He said to me, I push on the button and it's come out. I think in this time, 30, 40 years ago, they feel on the same way we are feeling now with AI. So, and we survived from 34 years, and we are still here. So I think in 30, 40 years, we are also still here, even we are now impressed and a little bit seeing, oh, what's coming up to us. So I think it's all the evolution, and only we have to be ready. So it's again said by Francesco De Pasquale to embrace everything and to try to implement it in our daily life. Now I want to go to our last speaker, Lina Evangeliou, who is a judge of the Council of State in Greece. Lina, in your role, what are the key needs you identify to ensure that technological innovation improve administrative course efficiency without compromising these individual rights? Please.
Thank you, Patrick. I must have also changed my intervention a bit in order to avoid repetition and overlaps with the previous speakers. So I decided to give you the example of Greece, what is happening in Greece, especially in the Council of State and the administrative justice in general. I serve in the Greek Council of State, which is the Supreme Administrative Court in Greece, and operates as well as a quasi-constitutional court. I echo. As a quasi-constitutional court, we have petitions for cassation against decisions of the ordinary administrative courts, And also, we handle annulment cases dispute as a court of first and last instance. As a Supreme Court, the cases are usually of great importance and have a great interest for the general public. So, as the significance of the cases varies, you realize that sometimes the case management of the cases, the management of the cases, is actually difficult and challenging. The main problem that the key need that we need to address as a court and the administrative justice in general was, of course, delays. As delays were depicted in all the reports of European institutions and other institutions, delays from the filing of a case until the final decision. But the main problem, as we all know, is not just delays. Speed can be tackled, can be easily achieved. I think the main purpose, the main need that any procedural, any technological, or any other development in the justice system is to provide timely judicial protection under conditions of equality for the litigant parties, while maintaining the quality of the decisions rendered for every court and especially for Supreme Court. And we should also note that this need must be served in a legal environment in which legislation has become increasingly detailed, technical, which adds to the difficulty of handling the cases. So these needs are being met to the best possible extent by procedural reforms aimed either at limiting the use of appeals in cases where important legal issues are raised, or more recently we had the reform in the pre-trial procedure for the adjudication of cases, as well as by strengthening human resources. We have created very, very recently two special branches of judicial clerks with specific skills in order to help assist the judges and prosecutors of the penal courts in their duties, and of course by a combination of technological tools. The progress there is spectacular for Greece, I would say, in the domain of administrative justice. Since 1999, the Council of State created, with great effort by judges themselves, an extensive legal database containing all its jurisprudence, all the decisions, and had a tool of the service of case law search in order to facilitate the judges in their research, and also to ensure the consistency, the coherence of the case law as a manifestation, obviously, of the right to effective judicial protection and equality of the parties, the litigant parties. At the same time, apart from being a tool for helping the judges in their research, the effort began for office automation for the workflow of judicial proceedings before the court through the digitalization of the court's register and the integration of various existing applications regarding the secretarial services of the court, which was achieved by 2006. Afterwards, an effort was made to unify the workflow of all administrative courts and all of their archives in order to create a centralized system where all the administrative courts and the Council of State are linked, and it's also interoperable with the Bar Associations of Greece, the Bar Association of Greece, and the legal representatives of the state. the services that we provide for external users are at their discretion the electronic lodging of procedural documents, and furthermore a service by which they can monitor the progress of their case by credentials that we give them through the system. At this point, a service that is not provided is the lodging electronically of all other documents that consist a case file, that is maps, reports, anything that every litigant wants to present to the court. Currently, we have a new project underway for the upgrade of the systems, and the scope is to achieve complete dematerialization of proceedings and workflow. Also, there is public access to a large number of anonymized decisions in our database, and the prospect is, by this upgrade, to have, for the public to have access to the entire case law. This would be very significant because, as I said about procedural reforms, we have a filter when filing an appeal or a petition for cassation in the court that is directly linked to the existence or not of a previous jurisprudence on the matter, on the legal matter. I also have to say that after the COVID experience, that we use the tool of a platform, electronic platform, to help us in our deliberations when we couldn't reach the court. A very recent law provided for the implementation of new forms of litigations in administrative justice via telematics. The project is the conversion of transitional courts into telematics court sessions. And also, the law provides for the possibility for any party to request to participate in the hearing using remote access technologies. I believe the last provision is just up to the point, just a provision. I believe that no steps have taken to the direction of its implementation, but it's a very significant step. That is the situation in Greece. Addressing the need for delays. Has it worked? Yes, it has worked. As we can see in the results as depicted in the Justice Scoreboard, the estimated time needed for resolving case in administrative courts is much lower than civil and penal courts that don't have an elaborate case management system that is currently under construction. As you can see, progress is being made, yet there is a lot to be done from a point of view of technological steps, many steps that can be taken, but also from a mentality point of view. We see that the e-lodging of procedural documents is at the party's discretion. It's not used to the extent that anyone would expect. Also, as Dr. Lämmer and Mr. Tallon said, we are guilty as charged as well for the printing of electronic files. Electronic file is the procedural documents are filed, and then a hard copy file is created for the judges to study, to assess, and for the court to have in deliberations. So you see, as long as it's a discretion. I think things will move a little bit more slowly. But there's progress made, and we have been able, and we will still meet the need of speeding up procedures.
Thank you, Lina. So we see in Greece the situation is on a good way, that innovation can really answer to the needs of the legal professions. We have still 10 minutes, so I want to ask to Victor if there are some questions online, or if there are some questions here from the audience. I know
So far, we don't have questions from online participants, but I'm looking at it. Maybe someone in the room.
And it's almost over, but we have still some minutes. If not, I have a question to Edouard. With all your big data, are you not scared to make the step to a sort of predictive justice? And what are the danger of it? Or maybe it's a chance, and maybe then the also can, but also there's a point of view about this.
Thank you very much. I think thank you. It's a very interesting and complex question. So it's hard to answer quickly, but I will answer quickly because also I was very long on the first question. I think it is indeed both opportunities on which I insisted during my presentation, but also risk. At the end of the day, it is harmonization of jurisprudence of case law, and there are risks and benefits to this harmonization. The benefits, it is legal certainty, consistency, which is more or less the same, efficiency, clarity, all that. It's the benefits. Also, because we need to have a harmonized application of law, we need to have legal certainty and so on. But we need also to have a certain flexibility. And this is also why people want to see a judge, because if the decision is entirely predictable, then there is no need for a judge. So it is really, and let's say that it's really a question of balance, to be aware of this risk, to be trained to understand this risk, so that we reach the good balance between certainty and flexibility.
Okay, thank you. All is about sort of balance between the different rights. Maybe the point of view of the lawyers on the predictive justice, that can maybe be the next step.
The quality of justice, yes.
Predictive justice.
What? The predictive justice, yes, of course. Now we have some recommendations in the CCBE about the use of modern technology, and also predictive justice is of course a good. It can be a good tool, but like everything that is human, it can be bad or it can be good. Let's hope that it will be a good evolution. What I was just thinking about also with this discussion is, I don't know if you read in 2008 or 10, it's long ago, Tomorrow's Lawyer of Richard Susskind. And there he was also speaking about evolutions and the fact that we have more and more legal products and not legal services anymore. And predictive justice is a sort of legal product. So, and legal products, I think also for the law firms, it is important to develop legal products, because I think via legal products, you can attract people to give them tailored services afterwards. But to make a judgment cannot be not tailored, so it cannot become a product. So that's my conclusion about that.
Okay, thank you. But Alex, I want to ask a last question about training, because we see we are from the legal professions and we are talking a lot about new technologies. And so, as you know, we as legal professions, 1 and 1 is never 2. It can be 3, it can be 11, it can be, we make interpretation of everything. But when you are seeing of the technical part, 1 + 1 is always 2. So how can we attract, because we have also some people who are not attracted by the new technologies in our profession, officers, lawyers, and judges and court staff, how can we attract these people to this new kind of training? Maybe you, Lina?
I'm not sure about that. I know that the digitalization of justice offers concrete benefits and in its current form. I'm not talking about AI that should require a legal framework to be thought, to be constructed, because it's a whole different thing. I don't know the mentality. What I said, lawyers don't use e-lodging much. We are tied to the hard copy of the file. I think as evolution progresses, we progress as well. What can be done? Seminars, educational seminars for all kind of users. But I think as we progress and while discretionary tools become compulsory, I think we're going to follow. And the technology that has already made our lives as judges very, very easy, and also has helped us to achieve, to meet the need for speeding up quality. I don't discuss it, was always a standard for us. I think it's going to get better. As I said, I don't get into AI because that's a whole different thing that I'm not sure we are ready for it, but and I see actually no real need because there's a lot to be done in a level of high digitalization on that level for us in Greece.
Okay, thank you, Lina. And maybe to Wolfgang, how can we attract all the court staff to follow this training and to embrace all this new technology and innovation?
Yeah, that's a difficult question. I wouldn't say anybody has to be convinced using technology, because even the greatest hardliner who is against using it, when you ask this question, why I'm not using it, he said, let me look my ChatGPT, what's the answer about it? So I think it's not convincing people about using, but it's helping them to make it easier for them. Because most of the new technologies you'll find in your normal life are made to make you more lazy. And that's what people in the courts also wish for, not to be lazy, but to have a little bit of air to breathe between the workload they have. So I think the most important thing is to develop systems that work self-explaining. And easy to use. And that doesn't mean it has to be a one-to-one to the printed version. It has to be something you can use like you use your TV, like you use anything in your household. So this is a very important thing. The other important thing that I think is always frustrating everybody in the court is the lack of possibility to communicate with others outside the court or even inside the judicial system, because there is no one unique language that is used. Very often you find the problem that you can't exchange data because the data has different structure and is not able to be read by your system and vice versa. So I think that this is something I would like to have in the future, kind of standardization of technique.
Okay, thank you. So I would thank you because we are ending the time of this roundtable. So I thank you all for valuable insights. And to conclude, I think we face all professionals the same challenges, and we also face the same risk and dangers. So it's also one more point after all this day to say that we have to stay together and try to continue together to face all this new innovation in our legal professionals. And thank you to everyone.